If you do have any questions during this webinar, please feel free to post them in either the chat or the question and answer section. Martin and I will do our best to address them, probably as we're going. Whoever's not talking will probably put those questions to the individual. And hopefully we'll deal with them in that way as we're going. If not, we can, if anybody's got a question they want to put it at the end, then they're equally welcome to do that. It's going to be me and Martin this afternoon. We're gonna, it's a bit of a mixed bag, essentially covering as much antisocial behaviour as we possibly can do. Initially, I'm going to deal with a few points of focus that I think are always relevant in antisocial behaviour cases, then provide a brief update on some interesting and important cases over the past year. And then there'll be a degree of focus from that point onwards, given the name, the word committal in our title, on committal proceedings, not least because the new CPR Part 81 now, not so new, but it's been enforced over the past year, and its application. And then Martin's going to deal with the closing end of that bit, which is the sentencing on that, and discuss a bit about the Civil Justice Council report as well. If I can just quickly, oh, do you know what? I've sent that link. I haven't sent that link to everybody, have I? There we go. I just realized I only sent it to Martin. That's entirely useless. Sorry about that. Sorry, everybody. I'm hoping that it was emailed to everybody beforehand, but if it wasn't, I'm going to resend again now to everybody. Excellent. So I'll give you all a little moment, but the first bit you don't really need to see the notes. So hopefully while I'm talking about those first few bits, people will be able to get those notes downloaded and in front of them. There were three kind of particularly important points that I think are relevant in relation to antisocial behaviour cases generally, which I always like to highlight when I'm talking about antisocial behaviour. The first thing that I always like to talk about is undertakings. Given that antisocial behaviour injunctions can expose clients to the mandatory ground for possession, it's always best to try your absolute most to avoid your client being subject to an antisocial behaviour injunction, even as an interim remedy. But we're also well aware that the courts invariably, when these applications come before them, are inclined to do something. They always want to do something. I think it's inherent in a judge that they want to do something, even if it's not as much as what the claimant wants. They're always looking for some kind of middle road point or compromise. And indeed, the legislation allows them to put in place an interim ASB, which can in some cases be just as bad as getting an ASB, not least because of the delays involved in these cases. It can take up to a year before you get to a trial on whether or not an ASB should be made permanently, by which time you could have agreed to an ASB that may well have expired by that point in any event. If you're going to be dealing with those cases, and if you've got a case where it's apparent that the power of arrest shouldn't really be applied, certainly at an interim stage, it's well worth taking instructions from your client and persuading them as best possible that if the court is minded to have something imposed in the interim, for them to give the promise by way of an undertaking to the court. That way, if you then have a breach of that undertaking, your client just isn't exposed to the risk of a mandatory ground. Obviously, they're in a lot of trouble, and they may go to prison, and they could equally, it could form the basis of a discretionary possession claim at a later point, but certainly protects them from the automatic mandatory ground. Oftentimes when I raise this in court, claimants say, well, we're not willing to accept undertakings. Well, it's not for them. It's for the court to decide whether or not an interim injunction should be imposed, whether or not it's just and convenient to do so. And it's for the court equally to decide, well, actually, if I've got a defendant here saying I'm willing to give a promise to the court that in all real terms it has the same effect as an injunction that doesn't have a power of arrest, then it can't be, in my view, rational or lawful for any judge in that scenario to determine that it is just inconvenient to make an anti-super injunction, and undertaking should be given. So always think about undertakings anti-super injunction cases. Of course, if you can avoid any interim measure being made at all, then all the better, or any injunction or undertaking being made, excellent. But a lot of our cases, that's very difficult to do, particularly at a first hearing. Further point that I want to raise before we get going into things is pre-trial settlement hearings. It's not uncommon in our cases of antisocial behaviour cases. In fact, I can't think of an antisocial behaviour case that I haven't had. I can't think of one that I've had for a number of years now, where there wasn't some form of underlying disability or mental health condition that was related to the case. I think practically all of my antisocial behaviour cases involve clients who are vulnerable in some way or form, and most of them have arisen largely because there's been a breakdown in a number of areas, both in relation to the care, in relation to support, in relation to adjustments being taken by the landlord, and more likely than not, it's a mixture of all three and possibly some other factors as well. And the reality is, for everybody involved, both the defendants and the landlords, the tenants and landlords, defendants and claimants, the litigation may well not actually resolve the matter, whatever conclusion the courts come to. The court can order an injunction or not, it can order possession or not, it can order damages or not, but a lot of the times that doesn't actually resolve the issues, particularly with vulnerable clients who are likely to be owed duty after the event of a possession order, after the event of an injunction and such like. And it may well be that, well, in fact, in my view, it practically always is, that the way that these cases get resolved is by having all the relevant people in the same room. You need somebody from social services, you need somebody from his local support and healthcare, you need somebody from the landlord, and you need somebody possibly from the family or support who's able to speak on his behalf or on your client's behalf as well. And you all need to be put in a room and have your heads bashed together, quite frankly, to find some way of resolving this case that brings an end to the problems that are being faced by others, but equally that looks in the long term to a solution that works for your client as well. And this is where pre-trial settlement hearings can be particularly helpful. They are normally put in that break in a trial after pre-trial checklists have been filed before the trial takes place. So all the material should be prepared. Everybody has a good idea of what each of a party's case is. You've got the expert evidence there to hopefully support your case quite substantially by that point. And a judge, equally, the judge who's listed for the pre-trial settlement hearing, he isn't the judge who's going to be doing the trial. So he's encouraged by the order to actually get involved, hear about what without prejudice offers have been made, and start kind of advising and pushing people towards finding a resolution to these cases. And I found them to be exceptionally useful in cases of this nature, of antisocial behaviour cases, to get positive outcomes, including agreements to pay damages to clients and such like, including agreements to move them. Another person, sorry, I didn't mention before, you may want to be there is somebody from the local housing allocations department. I've had managers of housing allocation departments, despite the ongoing housing crisis that we suffer, say, yeah, no, that's fine, we'll move him, we've got this accommodation available, or we have no problem doing this within 6 months, we'll move this person to somewhere that's more suitable for him, that the client is happy with, that the landlord is then happy with as well. These are all things that can be done that just can't be pulled off at a trial, and are resolved with substantially less expense being incurred, preparing for kind of these lengthy multi-track trials where invariably they get settled on the first day in any event. So it served as avoiding that additional cost for everybody and gets a positive result. I've known, I experienced these hearings first down in Southampton. They were a standard thing a few years ago. I haven't been to Southampton for a few years now, so I'm not sure if they still are. And I have known of judges, circuit judges at Central London County Court be willing to have these hearings and to engage with these hearings. So they're a great idea. Please try and pursue them. I put standard directions to the back of my notes in relation to them. So I would urge anybody who's interested in inviting a court to make that direction when at the earliest possible case management phase in the case. I've kind of wound down a little bit because my notes have, yeah, Microsoft Word has crashed on me, which is amazing. So all of my notes have just disappeared from my screen, which I see Martin is thoroughly enjoying. So if you can just give me 1 second. Just give me 1 second to close down my Word, and hopefully it will come back up in a second. Just I'm ever so sorry, everybody. Just right. What I was about to turn to was updates, case updates over the past year, some interesting cases. I'm still waiting for my document to reopen. Just 1 second. I think I'm back on a line, so to speak. So if you give me a second. Yeah, excellent. Oh, no, I wasn't. I was going to talk about review hearings. This is finally one very quick thing. If you do have a case where a mandatory ground is being pursued, that would be an introductory tenancy, or a case where they've committed one of the relevant offences or breached, found to have breached an antisocial behaviour injunction, and a mandatory ground is being pursued, and they've invited the client to pursue a review. I appreciate that a lot of our clients come to us too late for us to be able to do that. 9 times out of 10, they come to us once we're already at court. But if you are lucky enough to get one of those clients who approaches you at the early stage when the notice is first served, please put in the request for the review and do your best to engage with the process. I appreciate the legal aid agency doesn't fund this under certificated work, and will pay peanuts under the legal help scheme, if I understand it correctly. But they can produce positive results if you engage with the process, or alternatively, at the very least, you're going to get evidence that is going to justify some kind of basis for getting the mandatory ground struck out once you get to trial. My experience of these review processes where I've been involved is that they are Kafkaesque at best in the manner with which they're conducted. Having attended a number, I invariably find that by the end of the day, I've got a long list of public law and Equality Act breaches that took place throughout the day and would likely undermine any subsequent prosecution. But thankfully, to date, on those cases, my mere attendance and raising the issues has resolved in the cases not being pursued. Giving you some examples in the notes there, I had a case where, antisocial behaviour case, where the local authority were seeking to trigger an introductory tenancy, and on antisocial behaviour grounds refused to give any of the antisocial behaviour material, which they say they had obtained from the police, to the defendant's lawyers, to the defendant, but everybody else in the room had a copy. So the presenting officer, or the housing officer, the whole panel had a copy of it. And I was reliably informed this material is not relevant today. Well, in which case, why do you have it? In which case, why am I not allowed to see it? Lo and behold, they sought a brief adjournment where we were kicked out of the room. We came back in, we were told, oh, actually, we only wanted to give your client a warning, so we're going to withdraw the notice. I doubt that that is the truth of the case, but the presence of a lawyer, I think, in that scenario helped substantially. I had another one where we were making submissions on the public sector equality duty, and the query was raised whether the panel were aware of what the public sector equality duty was, and every single member of the panel said that they did not know what the public sector equality duty was, did not understand what I was talking about as I raised it to them, which again, I think was going to form a solid basis for a challenge had it gone ahead, but the notice was probably withdrawn afterwards. And another one where lengthy written submissions were put in, and the landlord clearly just didn't want to deal with it, postponed, and eventually dropped the case entirely without the review having taken place. I am willing to do these pro bono for any solicitors if they're interested in briefing. I should say this is not a fishing exercise insofar as work, because the reality is either we win them at the review stage, in which case there isn't any subsequent work that follows, or if we do lose, and thankfully that hasn't happened to me yet, then it's likely I would be turned into a witness in any subsequent cases. So in relation to giving evidence as to how Kafkaesque the hearings were. So, please do proceed with them, please do engage, and I'm happy to be instructed on a pro bono basis if anybody can find me being available. That's the only difficulty, it has to be said. Right, so turning then quickly to more the updates over the past year. I'm very mindful that I've spent longer on that section than I wanted to, so I'll be as quick as I can getting through all of the material before I pass over to Martin. There have been a few interesting cases over the past year, dealing initially with possession cases. There's been the case of Poplar Harker and Kerr. This, I see Martin has reacted, is...
I'm trying to send you a message, Michael. I can't get it, don't know how it works.
Okay. You're trying to send, do you want to, is it something that you can say out loud, or?
Yeah, I can say out loud. The case of Kerr is not being appealed on the tenancy agreement point.
Okay.
It's being appealed on a different point altogether, which is the use of Section 9, which is the Hopkins and Sheffield procedure, or the procedure that allows you to apply to stay or postpone a warrant, and introducing a mandatory ground. So, yeah, it's something that's basically not been decided in the two. That seems to be totally inappropriate.
Okay, that's useful to know. So in Kerr, and equally I cite a case of Finlay as well that's referred to in the notes. These are both cases that Martin was involved in over the years. These were assured tenancies which had conditions within them saying essentially we will only recover possession on the grounds of possession which are listed in the schedule attached, that excluded, for example, ground 8, which was in existence at the time that the tenancies were created. And the history is that essentially these tenancy agreements were worded in that way, largely due to these properties being transferred to housing associations as part of large-scale voluntary transfers. And the term of those transfers being like the housing association wouldn't be able to rely on ground 8, that tenants would essentially have tenancies as close to secure tenancies as they possibly could. But subsequently additional grounds have come into existence, and I still maintain there's an argument, albeit that Martin doesn't seem to have raised it on appeal on this one, that there is an argument that the fact that it says in the you can only rely on these grounds still binds the landlord. Personally, I don't understand why they're not required to actually vary the tenancy. If they want to vary, they're entitled to vary the tenancy condition, is my understanding of the position. So why haven't they done that? If they don't bother to do that, then my view is their hands are tied by the contract they have with the tenant. But to date, we unfortunately only have a couple of authorities out there, and all of them are county court authorities only, dealing with this issue. The case of North British Housing and Sheridan's a Court of Appeal case, but it doesn't actually deal with this specific issue. So it's still an outstanding issue, I would say. I think Martin suspects that.
No, I think
Martin's rather sick of it, but it's well, no, anyway, I disagree, because the case of British Housing and Sheridan was where they quoted word for word the wording in the grounds, and then they changed the grounds on a broader context. I don't think that's the same. They'd actually, the ground still existed, ground 14 or whatever still existed. It was just the wording contained therein, which had, I think, very limited significance in any event. That's not the same as this, which is a whole grounds of a different nature of mandatory grounds. But anyway, we wait to see. I mean, we stand where we are at the moment, which is that it's going to be a hard thing to argue at first instance, given those authorities, but certainly something that somebody may wish to pursue at a later stage. Redbridge and Courier, well, it's very briefly, that's a case where and I've seen cases like this as well, where particulars of claim essentially alleging antisocial behaviour, where it got to the bit where they were dealing with the allegations, merely said "see attached," referring to a witness statement. The district judge in that case, Judge Kemp, said that's not good enough. You've got to properly plead these, not least for the sanity of the individual who's drafting the defence. So a useful authority where you get this mess of kind of witness evidence being incorporated into pleadings, which isn't the right way to do things. So for those of us facing those things, that's a helpful authority. We then had last year, and this is slightly off-piste as far as it's related to public sector equality duty, but as I'm sure you're all well aware, whenever we do antisocial behaviour cases, public sector equality duty is very much the tenant's friend, as much as it can be. And we had two authorities last year on this, Taylor and Slough Borough Council in the High Court, followed by Metropolitan Housing Trust and TM in the Court of Appeal. Now, in Taylor and Slough, the principal gain was a re-emphasise that even where a landlord has breached public sector equality duty at an early stage, and in this case it was prior to the issue of proceedings, the court can adopt the position that that can be remedied by compliance with the public sector equality at a later stage. But equally in that case, and I've quoted the text there was a note of caution to say, look, that's not to say that the fact that the public sector equality duty hasn't been complied with at an earlier stage is irrelevant to the question of later compliance at the time of the possession hearing itself. It's necessary to find that the public authority has complied in substance with rigour and with an open mind. We all know that, and has commenced proceedings without complying with where they've failed to commence proceedings without complying with the PSD. It's important to guard against the risk of subsequent purported compliance tainted by the incentive not to depart from the decision already made. So that's what you're going to be wanting to focus on, and that is quite important, because then in Metropolitan Housing Trust, the Court of Appeal actually did dismiss a case which had been granted, where a possession order had been granted, on the basis that you can't. The judge in that case found that there'd been a failure to comply with public sector equality duty, because when the psychiatric evidence had been provided, there'd been no further review of their approach. But the judge decided that in the witness box, very much at the last minute, the last chance saloon, so to speak, the housing officer would remedy it by considering himself. Now, I find that surprising, not least given the actual account that the claimant's officer gave in that case, because he said in the box, apparently on the court authorities, it says he admitted that he would have tried alternative ways of dealing with the case if he'd known originally what he knew then, but he still felt it was reasonable and proportionate to pursue possession by the date of the trial. So he was very much tainted by the incentive not to depart from the original decision already made, and the Court of Appeal essentially said as much and recognised as much, and said that any further review that's going to remedy a breach of PSD must be part of an open-minded, conscientious inquiry, and further, that a belated act of compliance does not expunge any harmful effects of earlier non-compliance, and importantly, giving it in evidence it is just not going to be effective, because there's a real and obvious danger of confirmation bias. It's also a helpful example, that case, of how perseverance for those of us who pursue these cases can reward substantial rewards for those of us, because in that case the defendant had been unsuccessful before the circuit judge and before a High Court judge on appeal, both occasions losing, before ultimately succeeding before the Court of Appeal. Moving on, Bromford Housing and Nightingale. This was a case where a defendant sought to, his antisocial behaviour case, largely caused by antisocial behaviour of the defendant's children in that case. They sought to admit late evidence on the morning of the day of trial. It wasn't, I mean, in fairness to the evidence, I don't think it was particularly important evidence. It essentially was from a housing officer saying he's going to be found intentionally homeless, he's going to struggle to get, he's going to be ineligible for the housing register, both of which are apparent from the facts of the case in any event. He wouldn't be eligible for social housing, and the only other option would be private renting, which is unlikely to be able to produce anything. Now, again, hardly surprising facts, but material that could have been obtained earlier, the court applied the Denton principles, and the Court of Appeal backed up the judge in saying, look, you're the plainly entitled to conclude that late evidence shouldn't be admitted in those circumstances. It's a cautionary tale, and it just reminds us all, I think, that post-Jackson reforms, we can't be doing things at the last minute. But I think, in fairness, we all knew that by now already, so it's hardly a surprising case, but useful just as a cautionary tale and reminder. Now, there's a few cases on antisocial behaviour injunctions as well. And if you are going to read only 2 antisocial behaviour cases over the past year, I feel that the next one, Southern Housing Group and Berry, is certainly one of those. And then the one that I'll come to slightly afterwards, which is Rosebery Housing Association and Carr and Lane Williams, is the other. These are really helpful cases on how to essentially defend antisocial behaviour cases well, and an example of how to pursue antisocial cases badly on the part of landlords, I would say, as well. The Southern Housing Group and Berry case is a case where the housing association applied for a without notice antisocial behaviour injunction on an ex parte basis. And this was granted. It was actually granted by District Judge Naidu. But at that hearing, it was later discovered the landlord failed to mention that the defendant had serious mental health condition. It also failed to mention that the defendant had raised substantial complaints about the complainants, both to the claimant and to the police, and indeed that had resulted in action by the police against some of the complainants. As a consequence, this was raised when the defendant was properly represented, and the judge in that case re-emphasizes the principles on ex parte applications, provides a helpful summary of the law in that regard, highlighting that there is a duty to make full and accurate disclosure of all material facts. Material facts are those which are material for the judge to know in dealing with the application as made. And if we're looking at the situation in hindsight, the question is not whether the evidence in support could have been improved or want to be approached with benefit of hindsight. The primary question is whether in all the circumstances its effect was such as to mislead, its failure to disclose was such as to mislead the court in any material respect. And highlighted, because this is oftentimes you may wonder on an antisocial behaviour injunction case, well, okay, so maybe they did do everything wrong and didn't disclose all these matters, but the judge may have been inclined to grant one anyway. Well, the starting point where it's been found that they failed to comply with these obligations is that immediate discharge of the antisocial behaviour injunction should be likely to be the starting point for the court. And the court will still discharge the order, even if the order would have been made had the relevant matters been brought to its attention. It's essentially saying this is a sanction scenario. You have to demonstrate why the claimant has to demonstrate why they should be relieved from the sanction of not getting the injunction, given that they initially got it in a manner that wasn't consistent with the rules and practice direction. And in that case, despite there being quite substantial allegations, the judge felt that the injunction could not remain in force in all the circumstances of the case, and accordingly the order was discharged. Certainly well worth a read, I would say, to give you an idea as to the kind of arguments that work and are entirely justified in cases of that nature. Then there was another case last year, just before I turned to His Honour Judge Luber's case of December of last year. There was the case Metropolitan Housing Trust, Derrick and Brown, and this was a case where the judge essentially found it wasn't just or convenient to make an injunction, because the evidence wasn't there. And I think sometimes with our cases, we're a little too quick, and I think the courts were a little too quick to almost assume the claimant's case is correct. And I think this case highlights, look, the point is they still have to establish their case. And it may well be that your client is telling the truth, that these things haven't happened and things like that. And it's certainly well worth testing the case and the evidence and taking it forward. And hopefully you may well get a positive result such as in that one. Turning then to Rosebery Housing Association Limited and Cara and Elaine Williams. This is an excellent case that I'm sure a number of you will have already read, but certainly worth talking about. This is a case where antisocial behaviour injunction was sought against the defendant, who suffered from serious mental health conditions, including obsessive compulsive disorder and severe depression. The application was contested, and indeed a counterclaim for discrimination was raised. A series of bases that includes the disability discrimination, Section 15, but also harassment, reasonable adjustments, and there were also queries about compliance with the public sector equality duty, albeit that doesn't render a remedy in the end. And the claimant was relying on 6 sample allegations of at least 123 allegations that they'd lodged against this defendant in the case. And they completely failed to establish the 5 of those 6 allegations, and the only one which they did establish was one which the defendant had admitted. In any event, the judge found the evidence of the complainants to lack credibility, to not be consistent with the contemporaneous records, and indeed to be embellished and exaggerated. And the only one which the defendant admitted was a case where, essentially, in simple terms, she allowed a sound system to block out the complainant's sound system because it was causing her noise and nuisance in any event. And subsequent to that complainant leaving the premises, there'd been no further complaints about her being noisy in that regard, because she hadn't had to be to deal with the complainant who was being noisy. So as a consequence, the court refused to grant an antisocial behaviour injunction. It then went on to consider whether or not there was discrimination against the defendants. And importantly, because we do the most common, they found that found that discrimination had arisen, and that's consistent with Section 15 of the Equality Act 2010. Along the way, His Honour Judge Jan Luber highlights how much assistance he found from the assessor that was appointed in the case. So a useful case, again, when we're all worrying about whether assessors should be appointed to cite. And he also it's worth noting this case was he only found Section 15 had been breached. He didn't find there was a failure to make reasonable adjustments. He didn't find there was harassment. And he found that any breaches of public sector equality duty were pretty irrelevant in light of the finding on Section 15, given that it doesn't give the defendant a remedy or damages or any entitlement to a personal right, so to speak. Off the back of that, he went on to consider damages. Now, because we've all kind of swum around a bit in the dark on this, I think, and this has been a very helpful case for damages in Equality Act and discrimination cases, which I appreciate you came to hear about antisocial behaviour, but 9 times out of 10, I think Equality Act is going to come up in antisocial behaviour cases, and it's important to see in this context, despite there being substantial volume of allegations, albeit none were ever proven against this client, the judge, His Honour Judge Jan Luber, viewed the discrimination to be particularly serious, and I provided some quotes of his judgment, well worth reading. But the kind of comments that are being made could be easily transferred to any one of the antisocial behaviour cases that we face to this date. Landlords do get very entrenched into viewing cases in a very clear black and white manner, and that's particularly problematic where you have a client who's disabled and there fails to be any accommodation, and they just get entrenched and their behavior racks up the seriousness of any discrimination. So and that's apparent it's clear that's what happened in this case as well. And in that case, he went on to determine that they should be at the low end of the top bracket, which resulted in a substantial award of £27,500 to the defendant in that case. We should be running these cases, we should be running counterclaims, and we should be pursuing high levels of damages where the litigation and the case has dragged on for long periods of time, because that's essentially where the discrimination arose in this case. Their continued insistence on pursuing the matter against the client, despite, in that case, the judge saying that it was inexplicable as to why they were continuing, particularly given that the defendant was willing to give undertakings on those things. Finally, in the update section, we've got the case of another good case or useful case, because I've certainly had this come up in some of my cases. It's Plymouth Community Homes and Palmer. This is a case where the tenant got a dog. And I think I'd be astounded if most of us haven't had a case where a landlord said, but they've got a dog and they didn't, and then almost as a side note, because it normally comes up later down the line, they're complaining about somebody else, but also they've got a dog and they didn't ask for our permission, and we're not going to give them permission because they don't have a garden, albeit that it rarely has anything to do with any problems in the case or any problems at all. And in this case, the landlord wasn't happy that this guy had got a dog that was helping him with his mental health substantially. There was evidence to that effect. And they applied for an antisocial behaviour injunction for him to get rid of the dog, or may have been just, no, I believe it was an ASB. But anyway, they applied for an injunction to get rid of the dog. He counterclaimed for discrimination. It actually resulted in the injunction being refused, and he got damages of £2,500. So a really useful case that, insofar as your client may well be acting in breach of his tenancy agreement and getting a pet in, but if he's got a disability and it's helping him with that, and that wouldn't be very rare for that to be the case. I think that'd be quite common, in fact. You've got a good argument there, and certainly worth running. So those are significant cases over the past year that I felt worth talking about and worth relevant. I am looking at the time. I've got about 20 minutes there, I think, to just carry on for a little bit more and talk about Part 81 of the Civil Procedure Rules. Now, rather helpfully, at the end of 2020, in October 2020, the Rules Committee changed Part 81 of the Civil Procedure Rules. The idea was to create a slimlined and clear process as to how committal proceedings should be pursued. Prior to that date, there were a series of rules and requirements that were rather hodgepodge, and that part of the CPR was particularly complicated, in addition to having to reference other parts of the CPR, which was causing problems for both the courts, for defendants in not having their rights seen, and for claimants in getting things right in the first place. So we do now have CPR Part 81, which makes things a lot easier. Just as a preliminary point, I highlight in the start of my notes from paragraph 13 onwards that committal proceedings are criminal in nature. You're talking about a circumstance where Article 6 of the ECHR is relevant, and rules should be followed because they're there for a very prescribed reason. And I think as civil practitioners, despite the Jackson reforms and such like, now and then when procedural things happen, we're certainly less concerned than criminal practitioners would be in the same scenario. And it's well worth, when you're dealing with a committal case, kind of trying to switch into that mindset of a criminal lawyer representing a defendant. There are a lot of safeguards and protections in place for people who are going to be at risk of being sent to prison and subject to criminal sanction. And it's entirely proper for those procedural safeguards to be followed, and they're only to be disregarded in the most exceptional circumstances. So if there are breaches by a landlord, and there is quite a lot of requirements that need to be met, then certainly do not kind of overlook them. They could well form the basis of a sound opposition to any application for committal. I've provided a quote there, paragraph 18, that essentially says as much. That's from the White Book. So turning then to the rules, one thing that did happen with the introduction of new Part 81 was the removal of the old practice direction, which did have some interesting and helpful rules provided in there. For example, the fact that the court can strike out a committal application for any procedural errors contained, but when researching this, and indeed when researching for committal case, when I saw this practice direction had been taken away, I reminded myself that practice directions are not rules provided by the Rules Committee. They are a statement of inherent powers that existed in any event and continue to exist. So the removal of a practice direction does not necessarily mean, unless there's a rule to the contrary, that that power has been taken away. So just 1 second, I've had an incursion into my room. If I can briefly pause for a moment, I'm just going to mute myself for a second. Sorry about that. There was a demand for batteries. Anyway, moving on back to where we were. Where was I? Committal applications. Yes. So the inherent power to strike out a committal application for not complying with the rules still exists. So that still is there. So don't worry that that's gone away. That doesn't mean that the power doesn't still exist. And indeed, you should be trying to get things struck out where the rules aren't followed. Turning on. Sorry, I got slightly distracted by a few matters there. I'm back in the room, so to speak now. They've changed the wording rather helpfully as well, so that we're all back using the words claimant and defendant rather than applicant and respondent. They've put in place rule 81.4 is essentially the important rule now. The wording is slightly odd in that it essentially says what is required in a slightly odd way, but essentially everything that's in the list in 81.4 should be followed, and they are golden rules that must be followed. And if your claimant hasn't done that, then they're going to have real difficulties getting their case off the ground. That includes things like warnings about the consequences of not attending, warnings about your rights to not incriminate, and includes ensuring that a brief summary of the facts alleged to constitute the contempt are set out numerically in chronological order, and that's normally should be in some kind of schedule. Essentially, the application should contain what we would historically in criminal cases have referred to as a charge sheet, so that the defendant is well aware of as to what needs to be proved and clear on what they're facing, so to speak. There's a long list. I'm not going to go through all of those requirements. There is now a new form as well that should be used. And if the other side doesn't use them, they're rather setting themselves a rod for their own back. I did have a case this year where that was the case, and it didn't help them one bit, because it makes it a lot harder for a claimant to comply with the rules, because the form does provide most of the requirements. But of course, if the relevant answers aren't given in the right way on that form, then it's likely, again, the claimant's going to have difficulty getting this matter off the ground. When it comes to a contempt application, it needs to be served personally. That is, again, another slip up that is not uncommon for a claimant to fail to do or to miss, along with failing to ensure that the application has a penal notice on it, which again would be avoided now if you use the correct form. They have provided a system for service on the legal representative within the rules. This is where there are already litigants on board. That's to try and avoid lengthy delays and additional costs. Just 1 second, sorry. Sorry about this. I've never been this popular with my children. But anyway, moving on. um, there is provision for a court to essentially commit of its own initiative, though it's an exceptionally rare power and is only really likely to be used where somebody is committing a contempt in the face of the court. This is the kind of scenario where somebody's being rude or offensive and sent down to the cells and then invited to apologize later in the day. More importantly, coming then to directions, the court has a broad power to make directions on committal hearings. But remember, again, these are criminal proceedings, and if in nature, it's easy for us to forget, those of us who haven't done crime for a while. But in criminal proceedings, there is no disclosure obligation on a defendant. The prosecutor carries a much heavier disclosure provision, and it's advisable to invite the court to adopt that position. You definitely will want disclosure from a claimant in a case of the cases of this nature, but you don't want it to be list and copy document. You want it to be for the claimant to provide list and copy document, but not for the defendant to be subject to any disclosure obligation, save where the claimant can establish something specific that ought to be disclosed. Is my view and my position on this. Certainly, you're also going to want to look at what other bodies involved. It may well be that the police have been involved in the case, and that you're going to want to have disclosure of body cam footage, any records of interviews and such like obtained, and you may want specific disclosure provisions included in any order against, for example, the Commissioner of the Metropolitan Police to disclose this material if needs be. So those are the kind of things you're going to be wanting to think about in any directions. Disclosure is important, but be careful not to expose your client to incriminating themselves by virtue of any disclosure, by subjecting them to disclosure obligations, but get as much disclosure as you possibly can to help with your case. Turning then to the hearing itself, will be pursued on sorry, I've been ever so thrown off by the interruptions I've had this afternoon. I'm sorry about that. The hearing themselves, it has to be conducted in public as standard. Parties will be robed normally, subject to a judge changing his mind. Certainly, I did a 3-day committal this summer in front of His Honour Judge Sagerson, who refuses to ever robe, so that one wasn't robed. But normally, it will be a robed hearing, and that your client does have the right to not give evidence, and indeed, even if he submits an affidavit, it can't be taken as evidence against him unless he is called. So he may well have put in an affidavit in defence, but he may well not then come and give his evidence, and any such evidence can't be held against him in that context. Equally, his decision not to give evidence may be held against him in the standard way, as in criminal proceedings as well. But the judge will remind him of the client's right to not incriminate himself. You are entitled equally to make what is known as a half-time submission without it bringing an end to the case as a whole. As of right. So it may well be that if you feel the prosecution case doesn't meet what we know of in crime as the Galbraith principles, that there's, even if the defendant didn't give evidence, that the case wouldn't essentially be established, then you may well succeed at half time on that basis. Having said that, the judge, given that it's a judge rather than a jury, may well indicate early doors whether or not he's willing to tolerate such an application, but you certainly should attempt to make one. It may well be that there's an appeal point if that point is raised and the judge decides to force your client to give evidence, or push your client to the option of giving evidence in a scenario where there wasn't a case to answer. Where somebody is arrested pursuant to a power of arrest, then the power does still exist. And unfortunately, this is in a separate part of the CPR, in part 65, for the, despite the changes to the rules in part 81, for the court to proceed to commit the person. But that results in a very rapid progression of the case, because it needs to be dealt with within 28 days. Which can be quite frustrating and difficult, particularly when you're wanting disclosure and such to like from the other side. Certainly, if I were for a defendant and not happy that matters were progressing at that speed, you may well invite the court to not proceed once arrest has taken place and invite the claimant to make a formal application in order that proper time can be given to a case and it dealt with justly. And at that point, I believe I've made it to the end of what I was going to say. I apologize if it got very disjointed. Well, I know not if that it got very disjointed in the middle there. Apologies for the interruptions. If there are any questions, I can take them at the end, or I'm sure you can propose them as you go. And I'm going to hand over to Martin at this point.
Right. Okay, I want to focus obviously on sentencing, and in particular on the recent Civil Council report on antisocial behaviour in civil courts. If you Google it, you'll find it online without any difficulty. It was published in October 2020, but it's astonishing to me that most judges I've been in front of don't know about it. Many advocates don't know about it, including, and most worryingly, advocates for local authorities who are bringing the committal application. It's their duty, obviously, to inform the court properly of its sentencing powers. The Civil Justice report really makes excellent reading, and if you've got the time and inclination, download it. It covers virtually every issue. Extremely erudite and compassionate appraisal of the problems. So the two main issues on sentencing that it raises. The first is, don't forget that most of the criminal principles in sentencing apply equally to sentencing for contempt. And one of the points that's raised a number of times in the report is, frankly, the astonishment that so many of the judges that they interviewed or were training had no idea of many of these principles. And secondly, that the guidelines that everyone's been using for years, some years, and still are using, are basically not fit for purpose. And the report gives its own guidelines, which I included as an annex, which I'll take you to later on, which are substantially different. They're much more lenient at the start. And the criticisms of the existing so-called guidelines, I don't think they really are guidelines applicable to civil law, but they are being used. Also set out in the report, and you can quote those to the judge, saying that this eminent body of lawyers and judges have said that these guidelines are really not fit for purpose, and this is why. And I mentioned in passing that when the report came out, it's not enforced yet, in the sense it hasn't, all recommendations haven't been passed, but it was commended by the then Master of the Rolls, Lord Etherton. So, paragraph 52 of my paper, I set out most of the principles which apply, and which are some of which, anyway, are sometimes forgotten. So, firstly, purpose of punishment is threefold: punishment for the breach, secure future compliance, rehabilitation. So, rehabilitation bit that tends to get forgotten by judges who just get irritated by the fact that so-and-so is once again playing loud music and hurling abuse 2 in the morning. It's not just punishment for the breach. Before custody is imposed, the custody threshold must be passed, including suspending custody. What often seems to happen, and this again was highlighted in the report, is that civil judges seem to think, well, because our powers are limited, we can only fine or imprison or suspend prison or sequestration, maybe it does, or make no order. we have to make a suspended committal because we have to mark our disapproval, even though the custody threshold has not been reached. It's wrong in principle. You decide whether the custody threshold has been reached, then you decide whether to suspend. You don't suspend because you've got no other appropriate paths. Custody is supposed to be reserved for the most serious offences. It's not a useful means of batting someone to prison for a few days when they're causing a nuisance. If custody is required, then the least period, forgive me, if custody is required, then the judge must give the least period appropriate. And then once he has decided on, he or she has decided on the term, then decide whether to suspend. Some of this may seem repetitive, the same sort of principle rights in different ways. So, yeah, well, I've dealt with 5 already. A suspended sentence needs to be for a fixed term, it can't be forever. You do sometimes seem to get injunctions that are listed as being forever, which is wrong. But if it's until trial, that is okay, assuming the trials can take place reasonably in the foreseeable future. And the sentence imposed has to bear some relationship to the maximum powers of the court. And this becomes even more important when we consider the old guidelines, or the so-called guidelines, because the maximum power of the court is 2 years imprisonment. And that's 2 years for everything. It's not 2 years plus 2 years consecutive, so far, 2 years. The guidelines that are still being used by the courts relate to breach of criminal behaviour order, where the maximum sentence is 5 years. So you immediately see why it's not appropriate. Again, something which, at least so far according to the council, in their experience, they've come across is the custodial sentence being imposed because contempt or respondent can't afford to pay a fine. That's clearly wrong, but it's recorded as having happened. There are various guidelines, of course, produced by the Sentencing Council. They're equally applicable with all of these modifications to sentencing for contempt. And again, one thing which is often missed or forgotten is because the civil court has got no powers to impose a community order, a lot of the guidelines for the criminal courts reflect community orders as punishments, which obviously the civil court can't do. That doesn't mean that because the civil court doesn't have power to order probation or community service, it should impose a prison sentence. That would be quite wrong. Where someone pleads guilty of first instance, the totality of the sentence should be reduced by 1/3. It applies equally to contempt as to the criminal courts. Now, the report recommends that the total time that a person is going to spend in custody should be explained by the judge at the sentence. Well, this was a requirement at the time the report was published, was a requirement in the criminal courts. It's actually quite recently been abolished. Nevertheless, it's still, I think, good practice, because I don't think I've ever, I may be wrong, but I can't recall any case, I've been doing this for years, where a judge has actually condescended to tell someone, this is how long you will be inside. They have to go and wait till they go to the prison, and they're told by a prison officer. If someone is going to be sent to prison, they ought to be told when they can expect to get out, in my view. Now, there's a specific provision, Section 258 to the Criminal Justice Act, which provides that someone who's sentenced for contempt must be released when they serve half their sentence. And this is without conditions. It only applies to persons sentenced for contempt and for non-payment of fines. Specific provision. Now, with 13, we come to really something that's been a bugbear of mine. I've been doing this job for over 40 years, and this is, as far as I can recall, has always been the case. In crime, if you spend time on remand, it's automatically deducted from your sentence. You don't have to do anything. The same principle of time on remand being deducted from the sentence should also apply to a sentence for contempt, but it's not automatic. And it's astonishing how many practitioners and judges don't realize this. So the sentencing judge must be directed to take into account the time that the respondent has spent in custody. And it's your job, if you're representing them, to find it out. So the example I've given is someone is arrested on power of arrest on Saturday and is then produced on a Monday. That's 3 days when their liberty has been restricted. And that should be deducted from the totality of the sentence. But not only the 3 days, it's actually 6 days. Because half the sentence is automatically, you only serve half the sentence. The time spent on remand needs to be doubled. And paragraph 48451 of the report sets that out. I think it's also set out in the guidelines I'll take you to. And again, it's something which most of the judges that the council spoke to were unaware of. So the guidelines. Now, courts in the past, and I think still are, using guidelines produced by the Sentencing Council called Breach Offences Definitive Guideline. And particular guidelines, chapter 27, are breach for criminal behaviour. And as I said earlier on, the maximum sentence is 5 years. And for other guidelines, they refer to community sentencing, there's community sentencing that. But of course, none of that applies to the civil court. The civil court can't impose community sentence, and the maximum sentence is 2 years, not 5 years. And the whole thing is really designed to deal with a different issue altogether. So it shouldn't be used at all, in my view. Not only that, but I hadn't realized until I was researching this for this particular paper, but in fact those guidelines are now archived in the Sentencing Council, i.e. they're not really in force. They're old law. And the reason that they're old law is because Section 125(1) of the Coroner's Justice Act 2009 made it a sort of statutory requirement that a sentencing judge had to have regard to any guideline that they considered to be relevant. Well, subject to the arguments which I hear to, which I don't think these guidelines are, that's been repealed. It was repealed as of December 2020. So it seems to me that there are no guidelines other than the proposed guidelines Civil Council have put forward that the court needs to take into account. These guidelines are ex-guidelines. They're not going to Monty Python, but it's just I think it's inappropriate for a judge to be bound by these guidelines which are intended for a totally different purpose. I've also, you'll see, referred to a criminal case, the Queen Park Morgan 2018 case, criminal appeal reports, which predates the abolition of section of the Coroner's Act. But it's interesting because the Court of Appeal said, look, there's no duty on a judge to take into account guidelines which may be useful if they don't do a particular offence that he or she has had to sentence, which is exactly the case with the sentencing council guidelines. So, in my view, they should be not followed, and instead to follow the very useful model guidelines proposed by the council. And those are attached as a separate PDF to my paper. It's worth just having a look, because what they've done is reminded the courts of most of the points that I've already raised on principles of sentencing, and then follows a stepped approach. So, first step, identify the seriousness of the breach. And bear in mind, this is the only guidelines, proposed guidelines, which are tailor-made for sentencing for breach of NASB. And it sets out the tables to use, and then you deal with the arrangement. I won't take you all. I mean, it's there for you to read and hopefully print out next time to deal with this. But you'll see that the guidelines reflect the fact that no one should be sent to prison unless it's necessary, and it's commissioned with the powers of the civil court. Another power which the report recommends, which it does exist, but has sort of fallen into not quite oblivion, but it tends to be ignored, is deferring sentence. As I say, there's something that we used to occur quite often when I practiced criminal law. And I've actually persuaded courts in the past to use it in contempt proceedings. It's very useful where you want to encourage someone to take a particular step, whether it might be an alcohol or drug rehabilitation course, if we have courses, if they're available, or just to see if someone can keep their promise to behave themselves. And if you have a case where really the custody threshold is not reached, or it's reached a chest breach, fining is not appropriate, really what you want to do is to make sure the problem is resolved. A good way of doing that, maybe, simply saying, okay, well, look, I'm going to adjourn sentencing for 3 months. Let's see whether you can behave yourself or whatever. It's just an example. But again, one problem is it should really be the same judge. And these days, you never know what judge you're going to get. It might be a deputy or whatever, but or a coroner. But it's a useful, I think, a useful alternative. And finally, no order. It sort of speaks to itself, but just the fact that no order is made doesn't mean necessarily that the judge thinks that no punishment is appropriate. It can reflect a number of different circumstances. It's common sense, really, that for most people, defending a committal application is going to be horrendously stressful, be awful. That can be punishment enough. I had a case recently where the client just hadn't realised how much her behaviour had affected her neighbours, and was just in floods of tears. And that was the factor that I used. Mitigation is demonstrated. Really, that is punishment enough, and they've realised the effect on the neighbours of their behaviour. And also another time serving, as I say, people do forget. Someone's arrested on an arrest, and they're going to spend some time, some loss of liberty, and also there might be sort of monthly custody. So that's a sort of gallop through the main points of this sentencing powers set out in the report. It's already past 5. I just recommend that you, when you've got a bit of time, just sit down, just read through the report, or that part of the report, and the guidance, because it really is really good work in my view, and needs to be better understood and followed. Okay, that's. Oh, I see there's no questions.
Just seen one question there. I was worried that the chat wasn't working because we hadn't had any questions yet. But
Yeah,
thankfully,
I thought it wasn't.
thankfully, we've had a question. So this is a question: if standard directions don't apply to contempt proceedings, is it simply the case that the defendants are not required to comply with disclosing any relevant documents at all? Can you suggest some wording for disclosure directions? Now, essentially, if the court does make a disclosure order against the defendant, then you will be subject to the standard duties under the civil procedure rules. It's not that there's anything in the rules that says that they don't have that duty to disclose, but at the moment, save unless I think there's a pilot somewhere in the UK, unless you're part of the pilot scheme, unless and until a disclosure direction is made on a case, you're not actually required to disclose documents, save for those which you seek to rely on in proceedings. So provided the judge doesn't make an order against you, then yes, you wouldn't be required to disclose unless you wanted to rely on the material, which you would do as part of your evidence provision in any event. So in that respect, the direction would be, rather than it being the party shall provide standard disclosure by list and copy document, it would be the claimant shall provide standard disclosure by list and copy document. And so that would be the only changing I would suggest. If the claimant has arguments for providing additional disclosure themselves, they might not do that. Then they might be able to persuade the court to do that. But I think I would strongly object to any standard disclosure obligation being imposed on a defendant. In addition, the court may not be minded to give you a full standard disclosure obligation on the claimants, which isn't ideal, but certainly would be open to specific disclosure requests, I'm sure. And it all depends on the case as to precisely what the judge determines is relevant and such like. I don't know if you want to add anything to that, Martin.
No, I mean, it's often a good idea if you know what documents you think the other side have, which are going to be relevant, and you can ask effectively for a specific disclosure of those documents. And I don't see how a judge can use that if they're likely to be relevant to the committal application.
Anybody else has? Oh, here we go. No. What? So. Yeah, so I've had a question there. If there's no disclosure duty on the defendant, how can the judge order them to comply with disclosure? Well, that's where I think we're starting to err into me having slightly misled everybody. I'm not saying that in committal proceedings there isn't a disclosure obligation. What I'm saying is that there shouldn't be a disclosure obligation on the defendant, and it's for you to persuade a judge that there shouldn't be that obligation on the defendant, because of the criminal nature of the proceedings and their Article 6 rights. Of course, the judge may still, it's perfectly, the standard civil procedure rules apply to committal proceedings, save for that which is provided in Part 81, and 81 doesn't say anything about disclosure, unfortunately. So the only thing that I would say is in relation to evidence in that respect, because the next question that comes is they could say in crime, for instance, if you don't serve X by X date, you're unlikely to be able to rely upon it. But I don't think there's any power to order disclosure, and that is correct. But in equally in committal proceedings, it's well worth remembering that the court may make a direction for the defendant to give evidence by a particular date, and if they fail to comply with that requirement, they are still not barred from giving evidence at the hearing. They are entitled to give oral evidence themselves. I don't think that it extends as far, and I'm happy to be corrected, as allowing others to be called for you to call other witnesses. If you want to call your witnesses, you have to get your evidence in for them in accordance with any directions. But if you're talking about your own evidence, then even if you don't put in an affidavit, you are still entitled to give evidence in chief at your trial when it comes along. Though, of course, judges may well take a view on why you're holding back from saying anything beforehand. But that's a matter for you and your client to determine all the way. But there is that power, even if you haven't managed to get any evidence in, you are still allowed to stand up. The defendant is still allowed to stand up and say something, and advance a case and be cross-examined accordingly. Anything to add to that, Martin?
No. I mean, it would be crazy if someone should be prevented from defending their own case with a criminal sanction, just because they're in time. Yeah.
I don't see any other questions. I think we managed to drag this out long enough to bore you into submission. Apologies for my my rather broken bit of a webinar towards the end there. Is there anything further you want to add, Martin?
No, thank you all for coming, wherever you are. I have no idea where you tell.
The only thing I would add quickly is it's really useful to get your feedback at the end of these. So I'm going to share a link in the chat. It's a very, very short form that you can fill online. It shouldn't take more than a minute, I reckon, at best to fill out. It's yes, no. They're great, they're terrible. They're the kind of questions. It's and you can add comments as well. So, but you don't have to. So it can be as short as long as you want, but it can be very short. If you could, anybody who has come today, if you could fill out that form, it would be really helpful. We do take on the feedback, and it can be useful to give us ideas for what we're going to do next as well in our next series of seminars. I believe this is the end of our run of webinars, Martin. I don't think there's another. I don't think there's another webinar to advertise for next week. But I hope those who have attended this and other seminars have appreciated and enjoyed themselves. And yeah, sorry, Martin, I cut you off as you were saying something.
No. I think joy might be putting a bit highly, but.
Yeah, it's a good point. There you go. Or I've benefited from them, I suppose. But there we go. It's thank you very much for coming.
Thank you.
Thank you, everybody. Thanks very much.